Hello, welcome to the Ghana Agenda. My name is Alfred Amuzu. Today it's June 1st, 2024. And today we have only one issue that we'll be talking to you about today, which is whether or not the Attorney General of Ghana, in person of Godfred Dame, should resign. We are saying resign because so far we haven't really heard anything from the presidency as to whether they were going to let him go. So it is important that, when you're under this much fire, that you're able to make the decision yourself. So we ask it, should it resign? Should it just take into consideration all the things that have ensued since May 23rd when he was in court? While one of the witnesses to the case of the Republic versus, I believe, Ato Forson and Others were being adjudicated, and everything that came out so far. We heard the tape, we heard even applications currently filed to dismiss the case with affidavits sworn under oath, claiming that he, the Attorney General, had specifically told one of the accused number 3, that there's no case against him, that those charges were just brought up for whatever reason, we don't know. So we'll get into that. And today I would be joined by my regular panelist, Paul Disosu, and also Efa Ameya. We may have Joe Owusu joining us at some point, but as and when he gets here, we would introduce him. My name again is Alfred Amuzu, and you are on the Ghana Agenda. We'll take a quick commercial break and see if we can get the other guys into the studio, introduce the program, and then, proceed with the conversation. Again, this is the Ghana Agenda. We are on every Saturday from 2 p.m. to... Today we are going to just have a 1-hour show. Of course, we know the football goals will not forgive us because of the Champions League finals. And so we want to make sure we hurry up and get out of your way so you can go and watch a game. We'll be right back. All right. Welcome back to the show. We are waiting for everyone else to join. Guys, please let me know if you cannot hear me. Yeah. So as I was saying, 23rd May was just a regular day, and as you would expect, everybody, including yourself, going about your daily activities without knowing that day that Mr. Richard Jakpa would mount the witness box in a case against him, Dr. Cassel Ato Forson, and I believe one other witness, which is Dr. Sylvester Amenila, who was eventually let go because, the case against him was dismissed. But this day, we saw the witness number 3, or the accused person number 3, mount the witness box to testify. And this is after the prosecution has actually completed their cases. So basically the way it happens is the prosecution will go first, lay their case down, and once they rest, the defense counsel would table a motion for dismissal based on failure to, state the case, which means that the prosecution didn't state a case warranting a defense. Usually that is dismissed. If there is a prima facie, the judge will dismiss that. And once that is dismissed, it is time for the defense to actually mount their case. And when that happens, and this is the stage at which they were, the defense started their case, a witness was called, and this witness being Richard Jakpa. And when Richard mounted the witness box, he was answering questions being posed to him by the learned lawyer Eduji Atamaklo. And I think at some point, the Attorney General felt it was necessary to interject. And I believe, according to him, he was raising an objection to the questions and the answers being provided by the witness. I believe the witness to the effect that, a letter of credit that is supposed to have been issued by the then Deputy Minister of Finance, which is, the basis on which this case has been litigated, that letter of credit was not sanctioned, that it was, he was not authorized to do so. And so, Richard was being asked about that letter. It was presented to him, of course, for him to authenticate the letter, which he did. Then followed on questions came on the letter, on the, whatever memo, letter of credit, whatever that was. And then AG thought, that he needed to object to the answers being provided because to him it was favoring the accused. So he made the comment that, the accused number 3 is here trying to favor or defend accused number 1, which is Ato Forson, Dr. Ato Forson, the former Deputy Minister of Finance. And at that point, the witness went into, other revelations, including the fact that, the Attorney General has been reaching out to him in private, asking him about, specifically how to testify to things that are factual matters that he has different opinion on. In other words, the witness, has a knowledge of a fact that is different from the Attorney General's understanding of it. And the facts in question is whether the letter of credit was presented for, disbursement, or whether, it was presented for payment before the ambulances that they were meant to have paid for were actually visually cited, because there was a clause in the contract that says that, that the before the letter of credit, which was guaranteeing that a contractor who would have, invested into the, procurement of the ambulances and tooling the ambulances and shipping them to Ghana would be paid when those ambulances, do get to Ghana. And, the fact that, that clause, the condition precedents were not satisfied before the letter of credit was presented for payment constitutes, some sort of backhand dealing or some sort of financial loss to the state. And to this, both the Attorney General and the accused number 3 seem to have some disagreement on that issue. The accusations have been that the Attorney General have been reaching out privately to accused number 3, impressing on the accused number 3 to testify in specific ways, to say, things from the Attorney General's perspective when he goes to testify, to the extent that some of these meetings actually even occurred in the house of a Supreme Court justice, who is, by the way, related to accused number 3. Now, we are here because one of those conversations apparently was recorded, which accused number 3 had promised that he was going to release and did release. And so today our discussion is going to be whether what we heard on that tape, number one, because one of the things we're told is the tape was doctored, but one of the, we want to know whether one of the things we heard on the tape, if they constitute grave abuse of power, or if they constitute some type of criminality to where we'll say the position of the Attorney General has been compromised, that he lacks integrity and couldn't continue on the case or on other cases that are in front of that he's adjudicated courts. The whole reason for this inquiry today is that, I mean, all you have to do is Google Ghana and justice delivery, and you will see, the distrust and the type of articles published over the country. Even me, myself, doing the research, found that, a survey by Afrobarometer shows that the citizens of Ghana actually have a huge mistrust in the legal system. And when that happens, when the citizens don't trust the legal system, when they begin to think that, the judicial system is a preserve of the rich or the powerful, they begin to take laws into their own hands. So you could see that in our sub-region, there is a lot of people taking laws into their hand. There is mob attacks, all kinds of abuses of human rights currently and going on in the country. That's because, when somebody actually offends you, it is difficult to believe that you can get redress in court. And we know what happened in the courthouses, right? Sometimes you may have evidence that is solid, but if that evidence didn't pass the relevance bar, or if it didn't pass the hearsay rules and all the rules of evidence and civil procedure or criminal procedure, your evidence may not amount to anything. So people looking at all those difficulties, and one also lack of understanding of how the judicial system works, prefer to actually administer justice on their own. But the anchor reason for why people usually don't even approach the judicial system looking for redress is that, I think I have people waiting for me, is that they don't trust the system. They don't trust that justice will be delivered. Afa, welcome to the show. For whatever reason, I cannot hear, but let me know if you can hear me. Can you hear me, Afa?
I can hear you loud and clear. Can you hear me?
Loud and clear, but I cannot hear you, right?
Oh,
so I'm going to...
you cannot hear me?
A break so I can fix my hearing of you.
Okay.
Then, so that we can start. So just stand by. I will take one quick minute and we'll be right back to continue the show. All right.
Now I can hear you. Can you hear me? I cannot hear you. Can you hear me? Yeah, I cannot hear you. Okay.
That should be solved now, right? Can you hear me now?
Okay. Now I hear you. Can you hear me?
Yes, sir. I can hear you.
Okay, yeah. Now we're good.
Good. So Paul Disosu had asked that you join us in about a few minutes. So I want us to just do 1 hour today.
Is he doctoring some tape, or is he doctoring some?
Well, so again, you've already heard the defense that the MPP has raised. They believe that tape have been doctored, and we'll get into all that today. So, because considering that today is Champions League's final, I don't want to hold us unnecessarily too long.
Right.
So we'll do quick 1 hour, and maybe now it's 45 minutes because it's 2:16 now. So let's start. I mean, while we wait for Paul to join. So I was saying, May 23rd, any regular day, you and I probably going about our business, not knowing that there's a testimony going in court that would bring us here today, which is to the fact that accusations has been raised about proprietariness or, accusations raised about the fact that Attorney General of Ghana was consulting with an accused person who is represented without his lawyer there and having all manners of discussions, including one that was recorded, which has been played, and we've all heard the details of those. That tape, my understanding from the NPP is the tape is doctored, and we know the rule. When a tape is doctored or when you make such a claim, that you are supposed to adduce evidence to support that claim. We haven't seen any so far, but I'm sure you have something that you will share with us that is going to help us understand where that argument is coming from. I mean, what's the basis of such an argument is. So let me ask you the first question here. You've heard all the tapes. You've heard all the releases after that, which is the press conference or press statement released by the Attorney General. You've also seen the subsequent applications filed by the two remaining accused person in the person of Dr. Ato Forson and Richard Jakpa, asking the court to, stay the case or sort of discharge the case in their favor because
has Dr. Ato done that? Has Ato filed? Okay.
He has also filed an application. So we have those two applications now. And these are the applications, and I'm sure the basis of the they even stated in the application that, of course, the Attorney General had told Richard Jakpa personally that Richard has no case against him at all. That the case is actually just against Ato Forson. So he kind of begs the question, what is Richard doing in this whole debacle if there's no case against him? So my question to you is, listening to that, right? And I don't want you to be partisan here. Listening to that and just applying what you expect as a person when you go to court. Is this fair that an Attorney General would be in the back playing these roles, assuming the tape is not fake?
Oh no, we cannot do assumptions when we are discussing matters of the law. We can do that for purposes of commentary. We assume we speak to the facts. When you are dealing with the law, you cannot conjecture.
Yeah, that's the reason I say assuming is because
we cannot assume. We want to deal with what is there and what we think about what is there. Because the only person that can give out the exact pronouncement is the judge. It is your word against my word. Tendering in. We're going to take it, we're not going to take it, and then it's up to them. So this one has his opinion. I'm not going to be political though. Then that one has his opinion. Okay? But we cannot play the role of judges here. Get my point?
No. I'm not saying, I'm just saying that, you as a person, you go to court, you expect a certain level of fairness, right? You don't expect that the prosecution against you or whatever, if it's a criminal case, of course, there's a prosecutor, that prosecutor is actually talking to witnesses who perhaps have facts that favor you, telling them to not, state those facts the way they occurred, but to state the facts in the way the prosecutor thinks they occurred. Even to where witnesses are disagreeing, but the prosecutor still insists that, by the way, you are not in trouble. This is the person in trouble. Does that kind of raise any kind of doubt in your mind about, the fairness of our legal system?
Right. So thank you very much, Amizu, for this opportunity. And when we come here, we're going to be as fair as possible. Sometimes we become too partisan, but if we can be fair, that would be great. Before we went to the substantive case, you were talking about you going on research and finding out that justice delivery it's very poor in the country. And if you listen to some of the cases where somebody, I think the recent one that I chanced on was, I think, a student, right? He stole rice and rice and stew, and he's been jailed 15 years or something. And you have all these politicians walking around the corridors of power. But that is basically what it has been globally, though. You know, here sometimes when we have cases like what happened to Trump, we may think that the system here is so good and stuff like that. But there are certain specific cases that when you hear, because of how affluent the people are, Trump has really muddied himself. So he got caught with the law. It was obvious. But there are certain cases that people are also able to get away with because they have the money and stuff like that and all that kind of stuff. So justice globally is something that we need to deal with. If you listen to, it is not just, if you listen to Hobson, right? When he was incarcerated for just a day, people have been granted bail that are not getting out of the jail because they don't have people to speak to them. And he was even given a scenario where if it was not his position, that he would have spent more days than he did in prison or in cells and stuff like that. So these are issues that are very, very important that we have to discuss. And sometimes we discuss them when a big man is caught up in the justice delivery system, and then it is all in the news. All that is happening, there are tons of people that are being abused by the system, the police, the politicians, the court, and all that kind of stuff. Okay, so
Yeah,
that is a problem that we gotta deal with. But when the law catches up with the big shots, I am always happy. See, when something bad is going on in the system and it catches up with the big shots, oh, I like it because that is where they feel, and that is when they do reforms and stuff like that. So that is just on that. So let's go to the substantive of the case. Now, so we were told that there were a lot of evidences, not only one evidence, right? That there has been meetings and there has been recordings and stuff like that. So we were going to be blown out with all these stuff. So we had the recordings of a telephone conversation, okay, in which telephone conversation Mr. Jakpa is even making allegations of several meetings, several meetings and other evidences to adduce or blah, 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 and stuff like that. Now, the question is, as we speak, as we talk about this tape recordings, right? There are several connections to it, but it looks as if we've left everyone else out and we are only dealing with the Attorney General. Okay? How about the Supreme Court Justice who, quote unquote, met in his house?
right.
What does that speak to the whole concept of justice delivery?
Mm-hmm.
Okay, we know that there's a connection between the accused and the Supreme Court judge. And
Right.
under such circumstances, we know that even if the judge is on the case, they recuse themselves. Sometimes even if you and the client have issues, you recuse yourself.
Right.
On what basis was this, supposed meeting going on for? And it looks as if we don't want to talk about that part. We just want to talk about one part.
Right.
Is this a common practice that justices talk to lawyers to, do something to help somebody out because you're connected to the person?
Right.
You see, these are all things that, you see, and honestly speaking, in practical terms, I cannot be in a police station. They bring my relative
Mm-hmm.
there, and I don't do anything. I mean, it's not human. It cannot be human,
But
right?
it doesn't make it proper, right?
It doesn't make it proper. So
Mm.
where do we draw the boundaries? You see, when things like that come up, we have to box all these things. We don't leave certain things that is supposedly bad out because maybe it favors them. We don't want to mention that person's name, but it is important. It is
Well,
that part is very, very important. No, I want to bring that issue before I go into this thing. And I don't understand why the NDC don't even want to mention the judge's name. We know it was mentioned in the tape. So why do you leave that one out? So that is something. It is very, very important.
right.
It is very, very important because we are talking about the judge. Okay, or is that proper? Is it because it's proper? They
Well,
can do it. That's why it's been left out. That is fine. Now,
uh-huh.
let's talk about the case. the impression that was created. Okay, we
Mhm.
can talk about the mere meeting. That we can talk about the conversation, contacting the judge. But
Mhm.
we were told that the AG was coaching this person, right? That he was trying to get him to testify. I have listened to the tape, the 16-minute tape,
Mhm.
and I do not. Somebody can tell me the particular portion, the specific place where the conversation was. I want you to do this and this and that. Do it this way. And then the other person too said, okay, yes, I'm going to do it this and that way. I had a conversation about two people agreeing on letters of credit. And when it matures, when it's supposed to be issued, when it was
Mhm.
issued, the validity of it. And so one saying, I disagree with you. Because if I go by your position, it means I will do this and this and that. So I will not
Right.
take your position. And we all heard on the tape when he said, okay, I am not really asking you to help me in this case. I don't know if you guys did not hear that. And then on top of that, we had other things that were said. So for me, I do not see the coaching here, the solicitation for somebody to do something to favor somebody. If I had
Mhm.
anything, I had a disagreement. This is my position of what the situation is, and that is your position based on this. And this one is saying that if I agree to your position, I am innocent and I'm going to incriminate another person. And he said,
Right.
fair enough. That is my view. We can
Mhm.
argue about what someone else had that may add on to it. Okay? That is number one. Number two, you see, all that we are doing, just as was said the next day in court, all that we are doing here does
Mhm.
not affect the outcome of whatever is in court. And I'm glad that, subsequent to that, you have filed a mistrial, and this one has filed for innocence. That is, now we're talking. Okay? In the case of the NDC, you did a
Mhm.
press conference, a 1-hour press conference, but you did not even add the tape to it. Why not? You said this is your
You
evidence, right?
you say you didn't add what at the
They
tape?
did not add the tape recording to their evidence.
Where were you? Where were they supposed to add it? You mean at the court?
When they filed for the NDC has filed for a mistrial, right?
Yeah, the application to
Yes.
dismiss the case. Yeah.
And then Jakpa has also filed, right?
Yeah.
In NDC's evidence, they did
Yeah,
not add the tape.
Dr. Atos. But the thing is, if you know this, that such evidence don't get provided when you file the case, right? You file an application. It
Uh-huh.
is when you hear in the application that a witness would be, brought to the stand. For instance, you call witness number 3 to authenticate the tape. First, the tape has to be authenticated before it can be added into anything. You
Authenticated.
can just add it
The
to an
case is
application.
authenticated when there's a challenge to it. Now you
No,
are saying
no,
that.
no, no. I'm saying that even so, every physical evidence only come to the court through a witness, right? So they
Uh-huh.
have to kind of lay the foundation to the
Yeah.
witness and say, kind of give a little foundational information about the tape itself. As the witness, if he recognizes it, was he the one who recorded it, what day it occurred, the witness will admit to all that. Then you say, okay, you petition the court to say, Your Honor, may I please now introduce this as exhibit number, whatever, and then the judge will accept that. That is when it comes in. It doesn't come in when you are filing an application. You just don't add evidence without actually authenticating it through a specific witness. That doesn't happen.
Sometimes they do.
No, you don't. You don't.
No.
Every single physical, because the tape didn't record itself. How is the tape coming in? You don't just add it to that. You have to show that, hey, was that your voice on the tape? Were you the one who recorded it? You have to lay foundation for that. So you don't see anybody filing an application and then just
But what you are talking about, yeah, we don't need to go through. But what you are talking about, right? What you are talking about is when there's a challenge to it, or we are coming to court for the judge to. Okay, but what I'm telling you is that
every single evidence has to go through that process.
they have added
Witness.
they have added things based on which the case should be dismissed.
Yeah, in
filing.
in affidavit, yeah.
Okay, but
So,
did they say they have a recording to that effect?
but the content of the affidavit should tell you when. Okay, so when you have an affidavit which is under oath, and you add that to your application, you get called to the stand, to be crossed on that affidavit. And when you get crossed on that affidavit, that is when they introduce the physical evidence. You don't add the physical evidence. So the court system is such that verbal testimony is preferred over any other thing. That's why everything has to go through a witness. It doesn't just come in. You don't just file a tape with an application. That's not how.
Okay. But what I'm saying is that when you are filing your case, you are saying that so based on blah blah blah, I have this and this and that, based on which my case should be dismissed, right? So they said that the evidence for which this one should be dismissed is evidence that a person has made in court. Okay, one of which is what Jakpa said, right?
Right. And the court transcript.
With what do you back that? Just a mere statement from a witness that has not even gone under cross-examination by the other party?
The backing come in during the hearing. It's not. I'm saying that you don't file an application and add physical evidence. Nobody does that. The only thing you do is a statement of the person filing the application under oath, which they did through the affidavit in support of that. And they made all kinds of other claims. So all those other claims they made in the application and the affidavit supporting the application will come to life when they go to court to testify. That is when the judge will say.
Okay, but the claim does not. What I want to tell you is that the claim does not include the audio. But we will get there. We'll get there. Not audio as in presentation. Audio as in as part of their filing, based on what they're going to do.
You don't file the audio. The audio has to come through a witness. So again, the statements in the audio have been used as part of the application.
Audio has to come from which witness?
Through a witness. A witness have to authenticate because you have to lay foundation for this thing. So whatever
the witness is not the one who authenticates. It is the court. It is the court who authenticates.
Authenticating, right? It means identifying what that evidence is. You can't just say, "Oh, this is a tape that was recorded." It has to be that there is a tape recording. Are you familiar with this tape? You say, "Yes, I'm familiar with this tape." Is that your voice on the tape? Yes. To show that this is the witness has something to do, because you can't testify in court of something you have no knowledge of or you did not participate in. So it has to.
Who are you talking to? Who cannot tell who?
A witness cannot testify to something that they have no knowledge of. The witness have to have some personal knowledge of.
Which witness are you talking about here, though?
So in this particular case, right, you file an affidavit. Right, for application to be, you file an application with an affidavit to say you want your case dismissed, right?
Are you talking about Dr. Ato, right? Because there are two applications.
Both of them.
No. Let's deal with one, because I don't know what is in Jakpa's application. Okay.
Jakpa's application is telling you
there are two separate applications filed by two separate lawyers, not one lawyer filing for both.
Yeah, I'm saying Jakpa's application is saying that, right, that he has been coerced by the Attorney General, and he has evidence to prove that, and so he wants. He thinks
there's not going to be. I wasn't talking about Jakpa. I don't know if Jakpa added the tape recording as part of his evidence.
I'm saying,
or even said it in a statement.
Have to add. So maybe there's a misunderstanding here. Jakpa in his application doesn't have to add the tape. He doesn't. It doesn't. It's not done anywhere. Such physical evidence only come in through a witness. So whatever you are putting in your application, right? A statement that you put in the application, when it's time for you to prove that, that is when you get through the foundation. You lay the foundation. They introduce the witness, and the evidence can either be rejected or accepted. So how do you put an evidence that hasn't gone through that process into application and then have the court admit it? It doesn't work like that. That evidence can be rejected.
Okay. Let's accept your position for purposes of going on. I disagree with what you said. If I can finish, just go down. You can come in.
The law works.
You can come in. Okay.
I've read.
No. Can I finish?
Okay.
No.
Hold on for him. Let him wrap up in 2 minutes. So you can go. So if I have 2 minutes, I'm not going to interject no more. Just 2 minutes.
Exactly. So let's take yours. So even when they add that, right? I mean, they have not added it. They should have. Not the physical thing, with not the physical audio with it to go at the same time, but to state that these are whatever you have based on which you're going to stand on. But that is perfectly fine. It is not there. Now, even if we are to take this, when you listen to the tape, right, there was not, it's not something that you call like a normal conversation between two people. At one time, you see that two people are talking. At another time, you see it ends, and there is somebody that with a voice up and hammering down. So based on that, we believe that this is a tape that has been pieced together, and which we normally call has been doctored, and that it will not stand the test of trial. In fact, they cannot submit it because it will border on something things because it was going to go the authentication process and to pass the question of relevance and if it's even supposed to be admitted in the first place. Now, what we are saying is that
so you
case.
You mount the relevance bar, you mount the authentication bar, but you are asking that the tape be added to the application. If it's added to application, how that would it go through all those processes?
So when you send evidence to court, right? Okay, you send it to say that this is whatever. If the other party does not object to whatever you've sent, it is admitted in court and it will be used as part of the court process. But it is when there is an objection raised. It is when an objection raised. That is when, in the case of Ofosu, it has to go all the way to Israel. Now, if the Attorney General submit that to the court, right, and Ofosu does not raise anything, it is based on that they will use it against you.
Okay.
If somebody says something in court and you don't raise an objection, nothing happens. It is true. And then the judge will judge on and based on that to deal with you. Because you have already signed that whatever you have provided is true and a true representation. And that if it is found out to be false, you will be dealt with. So in you submitting it to them, you have. If somebody brings one that is contrary to yours to prove yours, then that is where they will deal with you on issues of perjury, whatever, trying to deceive the court and all that kind of stuff. We don't want to go through all those technicalities because that is a matter for the court. I mean, you may disagree with me on that, but that is perfectly fine.
There's nothing to disagree with. It's just civil procedure and the rules of evidence. If you are misstating the rules of evidence, so I've already tried so many times to kind of correct that, but it's okay.
Oh, that's fine. I mean, that's fine.
It doesn't work the way you are describing it.
That's fine. Yeah, I'm not going to challenge you on that. So what we are saying is that this is a doctored tape. The conversation was more on a misunderstanding. Somebody clearly stated their position. Two of them, I believe this is my position, and that one, and he also stated his position. Okay, so that is number one. I did not find anywhere where from the beginning of the conversation up to the end, where somebody was told that, okay, I need you to go to court to do this and say that on my behalf so that my case will look good. It was stated in the conversation that I don't really need you to help my case. Now, after that, okay, the Attorney General has submitted his case. Dr. Ato filed no case, and then the judge said, no, you have a case to answer. Then all of a sudden, they jump into their theatrics of propaganda and all these things to dismiss, to come to the outside of the case. Now, when you listen to the tape, right, one thing was very emphatic. He was saying that I am innocent. I am innocent. If you know you are innocent, why are you going for plea bargaining and writing and all that? If you are innocent, why do you wait for a judge to issue a bench warrant for your arrest before you come in? In which case you even got the help from the Attorney General to be able to take care of all this. Why are you trying to evade justice? You are innocent. You've done nothing wrong. And when you listen to the tape very carefully, you see a situation or somebody calculating something and trying to piece it in there, trying to force it in there, bring it to the public, and create a narrative for us to have a court trial outside of the court and not within. Let all of us understand that,
Okay, so we gotta move on, right?
Yeah,
Time
let
wise.
us all
We
understand that
have 19 minutes.
matters of law are dealt with in the courtroom and not in the media. You can do media to prepare your people's mind for defeat, but you have to come to court, adduce your evidence, and deal with the case. Thank you.
Okay. All right. Thank you so much, Afa. Paul the source, you've heard Afa. He's saying that, I don't know. You've heard him. So what do you think about this tape, Paul?
Mr. Muzo.
There's this allegation of piecing the tape together, doctoring it and all this. I mean, what is your take on that? Have you guys spent some time? I hear, the 10 minutes that you've waited, you were there doctoring something.
Mr. Muzo, good afternoon to you, and then good afternoon to my very good brother, if I may.
Yeah.
As you can, if you read from the demeanor, the facial look, and the way brother Ifa is, presented this case, you could see that this is something that he does not want to do, but he has no the choice because he has to do it because of his party. I know brother Ifa very well. Brother Ifa is not somebody who will defend this rot, this indefensible, charge that's been pressed against the Attorney General. What are the substantive case, or what are we talking about? I think when my brother Ifa was making his submission, he stated that the NDC has filed for mistrial. Let's correct the record straight. The NDC has nothing to do with this case. It is Dr. Ato Forson, the minority leader, who is a member of the NDC, who has been dragged to court by unprofessional, dishonest, and shameless Attorney General of Ghana. Why am I saying so? Mr. Muzo, you remember 2 weeks ago on Thursday in open court, when Mr. Jakpa was being cross-examined by Honorable Ato Forson's lawyer, that is Educhi Tamako, lawyer Educhi Tamako. It was through the cross-examination whereby the Attorney General interjected and asked for objection and made a statement that the third accused, which is Jakpa, A3, is trying to defend A1. When he made that statement really got under the skin of A3. That is Mr. Jakpa. And Mr. Jakpa was furious and said, do not try me, because I will put out all the secret meetings, conversations you'll be having with me just to help you make your case. And when Brother Ifa was doing submission, Brother Ifa do make a statement, which I'm so happy about. He says, the Attorney General stated that we do not need, Brother Ifa stated that in court proceeding, when somebody make an allegation or a statement against you, you have to object to it. Let it be on record that if Brother Ifa and the MPP are claiming that Jakpa's statement is an allegation, what stops the Attorney General, Godfred Dame, to put in an objection to reject that statement?
But
I did not say that though. I did not.
But even Paul,
I did not say that.
Statement, objection is a choice, right? You don't have to.
You don't have to.
You can, but you don't have to.
I'm coming there. I know it's a choice. If you can allow me to flow. I know it's a choice. You don't have to. But, Mr. Muzo, looking at the gravity of the allegation, considering the justice system in Ghana, considering the allegation and national security document that we all know of, which states that the general public perceive that the judiciary and this government are in bed, it was an obligation for the AG to have raised objection right there. If the AG knows deep down his heart that there is no between him and the third accused, Mr. Jakpa. If the LG knew that there's not be any exchange of document messages between he and Mr. Jakpa, he should have raised objection right there. What happened? He refused to raise objection. Her leadership, her Majesty, the judge, allowed this statement by Mr. Jakpa to go into the court document. Mr. Muzu, don't forget that Mr. Jakpa knows very well that he swore an affidavit and that he cannot lie to the honorable court. So for him to come out to spill out that dangerous statement, I don't understand why the Attorney General, looking at the office he holds, he did not reject the statement right there. That's number one. Number two, after the court proceeding, the Attorney General, the dishonest Godfred Dame, made his office to issue a letter. And if not the letter, I posted a letter on our platform and I knew they will come and deny. In that letter, paragraph 2, or no, paragraph 4, they categorically stated that they have not had any meeting with any of the accusers. It's in that letter. And it turns out that they themselves came out and said, no, there was a meeting. So you see, the inconsistency in the statement of the Attorney General and its outfit. Mr. Musu, you could also realize that when this thing was going on, the NPP tried to create impression, okay, that Godfred Dame was ambushed. The word ambush. It turned out that it's a lie. Godfred Dame rather called for the meeting. So Godfred Dame was never ambushed. That is lie number 2 from the NPP and Godfred Dame. The lie number 3 was that the NPP claimed that they have a video recording of Honorable Dr. Ato Forson going to beg the Attorney General to drop the case against him. As we speak, they've not been able to put that record or that video out. Now, let me jump into the recordings. You see, my grandmother told me when I was growing up that when a thief is being caught, the thief will say things and continue to change his statement and continue to change his statement. When the NDC took this issue up and stated that we have a tape recording that we are going to play it to shock the whole general public, whether IFA and the NPP thought they were going to, or we are going to bring the tape in which the recording happened in the house of the said Supreme Court judge.
Right.
Little did they know that the tape we're going to put in the family was a tape that was recorded on 18th of April, just 2 months, over a month, 2 months ago. They didn't know. Also, Mr. Musu, the fourth lie that Brother Ifa and the NPP told the good people of Ghana was that, okay, the Attorney General was it was Mr. Jakpa putting a plea back in, and the Attorney General rejected it, and Attorney General at the time he was speaking to him, Mr. Jakpa had no lawyers or had no lawyer at the time he was speaking to him.
Paul, use 2 minutes to wrap up for me because we are almost.
Mr. Musu, you are not being fair. You are not being fair. I have a lot of things to make.
Yeah, but you know we want to end.
It has also come to the limelight that that was a lie. At the time that the Attorney General spoke to Mr. Jakpa for 26 minutes, okay, Mr. Jakpa had a lawyer, and you know you are a law student, very soon to become a lawyer. Your ethical conduct says that when there's a case between two people, before you speak to the person, you need to consult the person's lawyer. So, Mr. Musu, I've outlined 4 lies in the letter that Attorney General put out there after Mr. Jakpa put out the bombshell in open court. Now, let's come to the tape. The NDC had a press conference and put out the tape out there. You see, my brother, let me advise him over here. If he doesn't know what is called doctored tape, he should stop talking about the tape is doctored. I am putting politics aside, okay? Unfortunately, I cannot disclose some things over here. But that tape that you're talking about, there is an application I use for my job I do. I run it through it. This tape is not a doctored tape. If you look at the sinusoidal waves of the frequency, okay, there's no way you can slide and join anything. It is not possible. And I'm going to ask Brother Ifa to tread cautious.
You said there's 26 minutes communication, but you released 16 minutes.
Hold on. I'll address that.
But we are running out of time though, so wrap up for me, please.
Mr. Musu, let's just take this topic for today. It's a very important topic.
Yeah, but
he has 8 minutes. He has just 8 minutes.
Yeah, we have to go watch the Champions League. Ain't you watching?
Okay, hold on. Then Mr. Musu, because this case is a very big case. I need to expose.
We can take it over.
We can come back next. Okay,
go.
We
can come back next week. Okay, let me quickly run up. So, Mr. Musu, you see, if I say that the tape is doctored, it was 26 minutes tape. How is that we are presenting 16? Where's the other 10? Mr. Musu, as I'm speaking to you right now, okay?
Right.
If I want to record this thing, I just have to go on my phone and click on the recorder. So, but if I knows very well that when you're talking to somebody, and the person sees that what you're saying is dangerous, he has to record you. The person can just click on the recording button to start recording you. Let me tell Brother Ifa that if he doesn't know, I know the information is out there. There are more tapes that is very damning than the one that's out there. So they should stop.
And you did not bring the super damning one.
Oh, we are holding it to our chest.
Oh my God.
You see, an attorney general who is asking an accused person to lie to the honorable court by going to take an excuse form to say he's sick, and Brother Ifa is here defending such an attorney general. I leave it to the conscience of Brother Ifa.
It is not criminal. It is not a criminal offense.
Oh, but Ifa, that's criminal, right? I mean, you can't forge. You can ask somebody to forge,
No, it's not. You see, okay. Did you go and listen to News File today? Okay.
Yeah, that whole portion was misstating. Like those guys misstated a lot.
Listen. You see, you guys have to and you see, when we come here, when it comes to matters of law,
let me ask you the question. So
hold on. It is you think I think. No, it is you think I think. We can only put the word on it when there has been a pronouncement on it.
Alfred,
other than that, it is you think I think.
Alfred, Alfred,
you should not resign.
You see.
Who? The Attorney General?
Yeah.
Alfred.
Hell no.
Alfred, let me make this statement. Then
no way.
Alfred, let me make this statement.
That stuff is nothing.
1 minute.
That stuff is nothing.
You see, Alfred.
Okay.
The Attorney General, as we know him, if he knows deep down in his heart that this thing never happened, the tape has been doctored, he would have been out long time ago to deny it.
Right.
Why is he not speaking?
Okay, listen.
Well,
let me address two issues. Right?
But
let me address two issues. First one about objecting when he made
2 minutes.
Yeah.
For two
the first thing about objecting, that is, it is a legal strategy. You don't tell the whoever.
But he has an opportunity to cross in the next.
Exactly. So if he
there's
doesn't
anything
cross
that he wants to
examination,
ask, he can
and
ask.
he does even during his cross examination, if he doesn't bring it up, it is up to him. It helps your case, right? Raise it.
Yeah.
That is number one. Okay, you have to get that. Now,
But then it's free. It's free for. It doesn't mean we are prevented from insinuating from his tactical application to not necessarily invoke or not necessarily object and not
but
bring
because
it.
but listen,
We can continue to
we
insinuate
can
from
do
that.
that. But
Maybe this is why.
because it is still a live case. All of us, our hands. The other time I made a comment that when you go to court, you are at the mercy of the judge, and people were telling me, no. Okay,
We are not calling judgment. We are not trying to be the judge. The judge has
I
her job
understand.
to do.
I
We are just
understand. But
opinions.
whatever we say here, one of us may win, right? At the end of the court, one of us will be pronounced right, whether we disagree or we don't disagree. Now, the question of the statement the Attorney General made, you see, when you complete it, he said he has not met to tell him to do this. That doesn't mean they have not met. Okay? Yes, we have met, but I have never met you and asked you to help me win a case or to go and incriminate this person. The Attorney General is saying that has never happened. But the Attorney General is not. That is why in the court, when he was making that, we have met. Okay? When you're making the meeting, because it is not just the two
So
of
the
them.
meeting that you were pointing to that took place at the judge's house is not meeting?
No. What you see, the statement Attorney General put out is that I have not met you to sort of induce you to go and incriminate somebody. We've met, all right, but not to go and incriminate somebody. That has not happened.
Right.
That has never happened. Okay? So in the whole context of what should happen in this case, you see, that is what I like about the law. We are dealing with specifics. The Attorney General has misconducted themselves. The Attorney General has done this. We have several platforms to deal with the Attorney General. We have the General Legal Counsel. You can adduce this. This is a live case. It is not a case that this has completed.
But this has impact on this specific case. It has impact on this specific case. This is where, in this specific case, the evidence that the Attorney General is using to prosecute one of the accused is being manipulated. So we can't say we have to wait till General Legal Counsel.
So it's being manipulated. It's allegation. What specifically? Mind you, the Attorney General has already closed his case. Now, this accused has not said anything that, this part and that part was information that are procured for the Attorney General to help him.
It's not up to the witness to make the Attorney General's case, right? It's not up to the witness to make the Attorney General's case for him, right? The Attorney General has. So the witness is now mounting his defense.
No, he's making another defense.
Can we revisit this case?
He was being cross-examined as part of his testimony.
It's allegation. It is not defense. He's putting it on that.
After the process is the prosecution opens their case and close their case, then the defense will say you have not stated a case, so dismiss.
Yes.
The judge will refuse. So then the defense has to open their case. And it is in that process that A3 was testifying. So it was in his defense that he was testifying, and he has to mount his defense. All he needs to show is 1%.
Okay. Let me stop you right there. He was being cross-examined, right? And then the Attorney General interrupted. You see, this one was something new. It was out of anger.
You know what?
He made allegations, not defenses. Allegations.
You know what?
What Jakpa said. What Jakpa said that has brought this recording. They are not defenses, so they are allegations.
We are out of time.
Of misconduct.
Okay, we're out of time. Paul, close us out.
Is it on the closing statement I'll make?
Man, let's show your face. Show your face. Don't duck anything behind the scene.
on my closing statement, I want to let Madifa understand that. Okay. There's a more evidence over the damning evidence.
All right. Put it out there.
If they come here and they try to defend him, they will bow their head in shame. Just like the way I told him about Martin Amid when he was appointed as the prosecutor,
the OSP.
OSP. He was praising when I told him to be very careful because this guy don't jump to the gun. You see, now Nana B, the national organizer, and all those people who were making noise, they've all gone to hide. They've let Brother Ifa, who is not getting anything from the party, to come and be defending this indefensible. For me, Brother Ifa is a good brother to me. I would advise him that he should stay away from this case because it is very damning. It's going to affect the core justice delivery in Ghana. It goes to affect our national security, standpoint. It's a big issue that we should not take it for granted. For me, if Brother Ifa is telling us this afternoon, hot afternoon, the temperature here is almost 92, that if an attorney general tells you to go and take a fake hospital excuse to come to the court, to come and present to the court, there's nothing wrong with it. I'll end and say, I'll leave it to his conscience. He should go and think about it. When we meet next week, I'll take it from there. That's all I'll say. Thank you.
Thank you so much. Thank you so much. Let's go. Close us out.
Yeah. So I'm not going to make no comments. I've said enough, and I still stick by. I don't think the Attorney General should resign. But it is not up to my opinion. It is up to those making allegations, adducing evidence. Because we all want justice to be served. I don't want anybody to be incarcerated based on false charges or based on coercion behind the scene for somebody to be put in. We are all against that because we support that, and one day it's going to be you. By that time, the system has already been put in place. So if they are real, let's adduce the evidence, and we are going to take it out from there. Anything short of that, this is law. It is not conjecture. It is not social science. It is not just opinions and stuff like that. It's up to the judge. Thank you very much, Amuzu, for the opportunity. We had wanted to really talk more on this, but we are being pushed by other needs to go in there. But as much as possible, when we come here, we want to do justice to the topic. We don't claim to know it all. We are limited in some cases by what we know as far as the law is concerned. If we say anything untoward, we don't mean to disrespect anybody. We want this program to be the best out there. And we also appreciate that when we come here, people sit behind the scenes, spend their time and watch us and contribute. We really appreciate that. And Amuzu, we thank you for the opportunity. Thank you.
Any predictions?
And may you be acquainted with the knowledge to always come and help us, address some of these challenges in the country.
All right, thank you. We know, Dortmund versus what is the name?
Real Madrid.
Which one do you think is gonna win? Any predictions?
I want to go for Dortmund because I was in Germany for a while. I haven't been to where Real Madrid is, but Real Madrid looks like the favorite. So we'll see how it goes.
Okay, perfect. You are going for that.
I own a football club actually in Ghana. One day we're going to talk about it.
What's the name of the club?
It's a second division team at Kintampo called Marvelous FC.
Marvelous FC. Okay. Marvelous FC.
Yeah.
All right. Good job. Good job.
All right.
Thank you, Brother Afa.
Yeah, thank you.
All right, listeners, there you have it. Afa doesn't think, Attorney General should be resigning anytime soon. Paul, I'm sure, wants him to resign. I'm sure you also, sees with your opinion on this matter. We'll be back next week. Hopefully, pick up from this if there's nothing new. But Ghana, something new is probably going to crop up. So, of course, they are moving the application on the 4th. The application to dismiss on the 4th. So we'll probably hear much more.
We'll get more evidence to talk about.
More juicy stuff to come and discuss. So, all right. Have a good one, Afa. And as always, I'm grateful for everything you do for the show. And for the listeners, thank you for hanging with us. Again, if we said anything like Brother Afa says that is untoward, please forgive us. We are all just learning. Again, my name is Alfred Amuzu. This has been the Ghana Agenda for June 1st, 2024. If it is Saturday, you know what time it is. We'll be back next week. Have a good one. Bye-bye.